SJC-12886, NextEra Energy Resources, LLC, v. Department of Public Utilities.
Mr. Frechette, thank you.
Thank you, Your Honor. May it please the Court, my name is Donald Frechette. I'm appearing on behalf of the appellant NextEra. I'd like to reserve 5 minutes for rebuttal.
No, I'm afraid you're not going to have a rebuttal, so you should use your time now. We don't do rebuttal during regular arguments, so you'll be spending your time now. Understood,
Your Honor. Thank you. This case involves a basic concept. Should agencies give full effect to the legislature's unambiguous pronouncements, or should they instead disregard the explicit terms of legislation in an effort to implement their own particular policy views? NextEra respectfully contends that the department engaged in the latter course of action and reasoned to achieve a desired result. In particular, the decision in this case failed to rely on record evidence to determine that the PPAs designated a discrete period of time during which hydroelectric generation would be provided without interruption. It likewise failed to make findings to support its determination that those PPAs provided for the delivery of hydro alone, and related to that lack of record evidence regarding hydro alone, also incorrectly found that the GIS tracking system would adequately assure that the power emanated from that particular source and was delivered in that manner. Let's take the easiest one of those first, uninterrupted service. Under Section 9.2F of the PPAs, Hydro-Quebec can have annual delivery shortfalls of up to 20% without triggering a default, and those shortfalls can be the result of unavailability of the Quebec line due to a physical condition that affects its transfer capability limitations. Simply put, can anybody on this call imagine coming home at night and as a result of system design, having nothing happen 20% of the time when you turn on your lights or your electric stove? Is that occasional? Is that inevitable, as the department suggests? NextEra says it is not. And this likewise has nothing to do with the straw man argument that NextEra suggests that force majeure means nothing in the context of this contract. This is not an issue of force majeure. Instead, it's an annual, temporally indefinite, and recurring right to deliver up to 20% less than what was contracted for. And that is the antithesis of firm service without interruption. That brings us to the second issue, whether the power is from hydro alone. The department suggests it's sufficient for the power to be generated from hydro, but as opposed to being actually delivered. But the Commonwealth is paying for hydro. Shouldn't it be getting hydro delivered to the contractually agreed upon delivery point in Maine? NextEra implores the justices to ask the obvious. Why, if the objective is to obtain hydropower, does the transmission line in this case originate hundreds of miles from the nearest hydro facility, but right around the corner from other forms of energy? Why is the transmission line not tied, as can be done, exclusively and directly into a hydro plant? It's telling that the only expert in this case who testified on behalf of NextEra is the former COO of ISO New England and the former CEO of ISO New York, and he testified the transaction would not deliver and could not be tracked by the GIS tracking system to deliver hydro alone to Maine. Despite his credentials, the decision doesn't even mention that he testified. That brings us to our third claim, the GIS tracking mechanism. Again, NextEra experts testified that the tracking system could not determine whether the particular power being delivered to Maine was hydro. That testimony wasn't even mentioned in the decision, and instead, the department simply relied upon NEPOOL's own website for validation of its tracking capability. And while NextEra acknowledges that NEPOOL is certainly a recognized tool in some contexts, there's nothing in the record that demonstrates that it has ever tracked hydro alone internationally in the unique context of this type of contract, also as to validate that the Commonwealth got what the legislature commanded, hydro and hydro alone. So as I conclude my opening remarks, I'd ask the justices to simply consider, why was Hydro-Quebec itself never asked to explain the contract terms, the unique contract terms, the first impression contract terms that we will discuss here? Why was the expert testimony regarding tracking system capabilities not even addressed? Why did the PPAs allow Hydro-Quebec to fall 20% short each and every year and still be characterized as firm service without interruption? And how is it that the Commonwealth can purchase hydro but not be guaranteed to get hydro? We submit that those are all important questions, and that they have not been answered by the decision, that a remand is appropriate for the department to examine the available data and to provide sufficient findings for its outcome. I'm happy to take any questions that justices may have.
Thank you. Justice Graziano.
Thank you. Mr. Fischette, recognizing, of course, that you have a large burden to overcome in the deference we're bound to give the department, and you call these unique contract terms, and perhaps it's the way that the statute is written, but you seem to be asking for metaphysical certainty in a very, as we know, uncertain world as far as the interruptions in the hydro requirement. Isn't the department allowed to use common sense in interpreting the words the legislature has passed?
Absolutely, Your Honor. And if I might respectfully disagree with two aspects of your question. First, the burden that confronts us. I would respectfully submit that while the department is obviously entitled to deference when it comes to the interpretation of the statute where ambiguity is present, the department is not free to disregard the express terms of the statute.
It has to be supported just by substantial evidence. It's a 30A review, right?
Indeed.
And we defer to the agency's expertise, and we have a 30A substantial evidence test, correct?
Correct. I do not, however, believe that there was substantial evidence presented in this case, and that brings me to the second prong of your question, which is this request for metaphysical certainty. That is a straw man. That's a straw man that's been set up by our adversaries. In this particular case, I implore the court to look at 9.2F. This is 20% per year is not inevitable. 20% per year is not occasional. And certainly there's nothing in the record that substantiates the idea that 20% per year, every year, is something that is appropriate, normal, or recognized within the industry.
Does it depend upon an assumption on your part or your client's part that that there's going to be a contract breach? Because there are disincentives, financial disincentives for interruptions, correct?
No, absolutely. To answer your first question, no, it does not require a contract breach because indeed when one examines 9.2F, that particular section says that up to 20% is allowed annually without a breach resulting. So, no, it is not dependent upon the existence of a breach.
Those are all the questions I have, Chief. Thank you, Mr. Fischette.
Thank you, Your Honor.
Justice Louie.
My area of inquiry is really the same area as Justice Graziano, and I'll ask you to explain the 20% in 9.2F maybe in a little bit more detail in a moment. But I understand that you contend that these power purchasing agreements are not establishing firm service, and that these potential interruptions might reach 20%. But my understanding is that the PPAs do require firm service. And I guess, we live, as we just discussed, in a world where sometimes it's uncontrollable events and could have COVID-19 pandemic, and that could impact the way power is used, for instance. So we have these covered damages provisions, but it's hard for me to understand with the deference that is afforded here how there shouldn't be an interpretation of the legislation that recognizes that sometimes there's going to be interruptions in service, there's going to be transmission issues, there's going to be even uncontrollable events. Isn't that just inevitable?
Your Honor, I don't want to repeat myself, but with respect, I think I have to. There is nothing inevitable, and there's nothing in this record that suggests that this is in consonance with industry practice to have a contractual out as set forth in 9.2F that allows for annual losses of power generating capacity of 20%. That's not unusual. That's not usual. That's not normal. And let's take the department's suggestion that firm service means, well, service that's available subject to the normal interruptions that one would expect. The department has never, well, first of all, I have two problems with that. The department says, look at these other cases. They all talk about firm service, and that just means service that's available, and this service is available for the term of the contract. But the legislature didn't stop there. The legislature said firm service without interruption. Those are additional words. And I am not here for 1 second to fall into the trap that the department would like to set of saying we want service guaranteed through every possible circumstance known to man. 9.2F, over and over, I will say it, tells us that there are circumstances far beyond the inevitable, far beyond the normal, far beyond the occasional. 20% is not occasional. And to your other point, which is the deference of the department and its interpretive capabilities, absolutely. And we understand that, and we understand the burden that we have before us. But by the same token, I would submit to the justices that interpreting a statute, there are limits. And you can't take the language that says you'll provide firm service without interruption and turn that into you'll provide firm service without interruption except for 20% every year without incurring a default. That is a bridge too far. And that's not interpretation. That's allowing a contractual out that is not present or recognized by the statute.
Thank you. Thank you, Chief.
Justice Budd.
Hi, good morning, Mr. Frechette. Let me just ask about this tracking system that they had planned to use. I understand that, what is it? How do you say it? NEPOL? N-E-P-O-L? NEPOL. So my understanding is that it's widely used. It's apparently the industry standard. Is there something that you know about it that the department doesn't know that, that they should be aware of?
Well, Your Honor, it's to my knowledge, and I don't believe the record demonstrates, it has ever been used to track power alone, hydropower alone in the international context. Moreover, I understand the idea of a recognized system, but when the available evidence in the record by the only expert who testified and the only expert who's actually operated an international system says it's not capable of doing that. By that I mean tracking hydropower alone. And the only counter evidence is, well, it's a great system, everybody uses it, and look at their website. That's not a substantial finding. That's not a substantial basis upon which to predicate an outcome, especially without any explanation as to why that only expert's unrebutted testimony, an expert of substantial qualification, is left entirely unaddressed by the decision. And in that regard, we point to the Fitchburg case. There has to be some recognition of that and some effort to address why there's absolutely no rebuttal to that testimony.
Okay, thank you.
Justice Safer.
Thank you. Good morning. Can you give me an example of what kind of explanation exactly you would like?
I'm sorry, Your Honor, I don't understand your question.
Well, you said that the example that was given when you answered Justice Budd's question, that it was inadequate, that the explanation was inadequate. So I'm wondering, in your own words, what would a good explanation sound like? Well,
quite frankly, I don't think there's going to be a good explanation in this case, and that's why it wasn't addressed. Because the NEPOL system is not capable of tracking internationally hydro alone, as the expert indicated. But that's kind of the point. If there was an explanation, one would think that we would have heard it. I don't think there is an explanation.
Okay, thank you.
Justice Kafter.
So what is the NEPL system capable of tracking? If you all rely on it, right? You rely on it for a bundle of other things, right?
That's correct. And Your Honor, I'll be candid with you. I don't believe I have the technical capacity to answer that question, other than to say that I would defer to the record in this case, which demonstrates overwhelmingly what it's not capable of doing. And it's not capable of tracking hydro alone.
I'm not sure how that's clear. If it's a system that tracks stuff in the industry with reliability, in fact, you all trade credits on this system, right? You're allowed to bargain for these credits, right? Pass them around.
I believe that's correct.
Okay. So how about the transmit? You talk about the delivery versus the transmission. So should they had to build new transmission lines? Is that what you're requiring them to do to ensure that it's only transmitting hydropower? I'm trying to understand what you want them to do.
What I want them to do is to satisfy the statute, Your Honor. And
but what does that mean? So in the real world,
in the real world, that means. I'm sorry.
Go ahead. So how in the real world is what you're saying is they should build separate transmission lines in order to do this?
In the real world, that's exactly what has happened in other instances. There have been.
Where has that happened? Where there's already existing transmission lines?
Vermont is my understanding, Your Honor. We have a situation here where this line begins literally hundreds of miles from the nearest hydro plant, and yet just around the corner from generation facilities that are linked to other forms of generation. You have to ask yourself why that is. And we would submit it because the power is not coming from hydro alone. Yes, Hydro-Quebec has the capacity to generate the power, but there's nothing that suggests that what we're getting is what we're paying for. And
well, they're also required to produce this number of watts, right? So we know they're required to produce this number of watts. We can measure whether they're producing this number of watts, right?
That is correct.
So the issue is we want a separate delivery system to ensure when the electricity comes in, the hydro-powered electricity comes in, it can be separated from the other types of electricity. Is that right?
That's right. And because, Your Honor, I ask you to think about it this way. I mean, the Commonwealth is paying for this. The Commonwealth is paying a premium to be the leader in this area. I mean, nobody's doing this. Well, it's kind of funny. I was about to say nobody's doing this for their health, but actually that's exactly why we're doing it, is for our health.
But they don't want wasteful expenditures, right? They want clean energy expenditures, not sort of unnecessary expenditures, correct?
I would say if one follows what the legislature said, they want clean energy expenditures, and they're willing to pay for them. What instead the department has said is satisfactory is you can pay for clean energy. It may go someplace else. Somebody else may get the benefit of what you're paying for. And so in some global sense that, we all live together on this rock that hurtles through space, we're all getting kind of the benefit of that. But I would submit that the legislature did not contemplate a result where the Commonwealth pays for something for somebody else to then essentially receive the delivery of it.
My last set of questions goes back to the 20%. So what would be, we live in an imperfect world on your rock shuttling through space. What would be a reasonable percentage?
Oh gosh, Your Honor, there's no way that I'm competent to state that, and that respectfully is exactly the point. I would submit to the justices, unless one of you has training in electro generation that I am unfamiliar with, that none of us are capable of.
But that's why we owe some deference to the experts, right?
Well, but we don't know experts. I would say this to answer your question, and by the way, let me globally say, I certainly am never intending to walk on any of the justices as they speak. I hope they understand the imperfections of this system, but
believe me, we understand that. It's not your fault. It's COVID-19's fault. So go ahead.
Thank you, Your Honor. What I would say is this. I don't believe that any reasonable person sitting here contemplates walking home 1 out of every 5 business days and not being able to cook your dinner on an electric stove. That, under any scenario, is not reasonable.
Well, but isn't that, I mean, it's sort of backwards, though. But one other question, the 20%, when everyone was bidding on this and when people were talking about it, was there a percentage that was being batted around that everyone was aware of, or did this 20% come out of nowhere?
The 20% came out of nowhere. That's part of what our quarrel is with the idea of this, the department's deference. This isn't a rate-seeking decision, that one anticipates seeing all the time. This is a unique statute being applied for the first time, and there was nothing in the original materials that talked about firm uninterrupted service, meaning, firm uninterrupted service except for 1 out of every 5 business days. That was a throughout the bidding process, everyone thought you had to have 100% perfection in terms of hydroelectric power. And then when one side won, this 20% came out of nowhere. Is that right? I don't want to say that everybody thought you had to have 100%, because I've already conceded that there is some frictional loss that one can attribute to the inevitable, the unusual, the plagues that apparently can afflict us from time to time, as we're experiencing now. What I would suggest is that the 20% was not something that had been envisioned by the legislation, not something that had been envisioned by the initial publication, and something that came in much later in the game.
Thank you. That's all I have.
Chief Justice Gantz, the statute refers to uninterrupted service, correct?
It does.
Where does drought fit into all this, by the way?
I'm sorry?
Where does drought fit into all this? Is that within the realm of force majeure, or is that outside of the scope of that? What happens if we have an Australia-type drought in?
Well, I don't want to be flip, Your Honor, and I will directly address your question, but I would say where drought fits in is not 9.2F. 9.2F doesn't cover drought, but I would say that drought, if sufficient to address or sufficient to give rise to a force majeure event, would fall into the provision of the contract that explicitly excuses, as one would expect, force majeure. And I come back to this point. The department has stated that we out and out are attempting to write force majeure out of the contract. Never did, never have.
But you would place drought within the realm of force majeure. I just don't know the precise meaning. I know it means wars, but I don't know whether it includes droughts. So you would say that falls within the realm of force majeure. How about a broken transmission line, either because of sabotage or just because of maintenance issues?
Well, certainly because of sabotage, that might be considered force majeure. I've certainly seen more than a few insurance cases that talk about force majeure, including acts of terrorism. Lack of maintenance, I don't think lack of maintenance is force majeure, which brings us back to 9.2F. 9.2F allows a system that's incapable right from the beginning, that has built into it a 20% slippage factor of providing the Commonwealth what it's paying for. And that's our concern, that this system was designed from the outset to be inadequate for its intended use. And 9.2 provides the contractual out to capitalize on that inadequacy.
I mean, your brother will note that when the 20% is if there's any shortfall, they still have to pay cover damages, correct?
That is correct.
What is your view as to whether it's appropriate if the locational marginal price is negative? Are they still supposed to deliver?
No, we've not argued that here. And quite honestly, I think that if 9.2F weren't in the contract, we might have a different view on this. Our primary focus is 9.2F. What I would say, though, on the issue of marginalized pricing is, again, there is, and as with all laws, the laws of economics admit of exceptions as well. One would expect there to be some type of analysis that suggests that LMP pricing, always must lead to inefficiencies. What we saw from the department, however, was that it could without any analysis. So I think that's an open question, but that's kind of the point. Again, it's something that was left unanswered by the department. And I just don't believe that when one is dealing with something as black and white as firm, uninterrupted service, the department should be leaving unanswered questions that turn on words like could and may and might.
Now, I should know this. What does NextEra do?
NextEra is a power providing company.
And what kind of power do you provide?
My understanding is that we are across a mix of power sources.
And were you a bidder among these?
We certainly did have a counter proposal, yes.
What is what's the practical consequence if we were to say that absence of interruption means absence of interruption, and any interruption for any reason other than force majeure would be a breach? And if we were to say that the NEPOOL tracking system does not adequately ensure that the power being delivered to Massachusetts comes from hydropower, what's the consequence? Do we basically say we just can't use hydropower?
Well, a couple of things are the consequence. First of all, we're not asking for the court to suggest in black and white terms that these things are not capable of being achieved. What we're asking for is the court to remand this proceeding so that there can be appropriate findings that would allow the court to exercise its judgment as to whether or not the department properly exercised its discretion. We suggest that the existing record is deficient in that respect. And so I politely dispute Your Honor's premise that we're essentially asking for a particular outcome here. We're merely asking for the department to provide us with the rationale so that we can then determine whether that rationale was appropriately applied. We don't think the decision even provides a rationale. It's long. Nobody questions how much time went into it. Nobody questions the amount of witnesses and evidence that were produced. But when one looks at things like the PPAs provide for firm service because they say they provide firm service, that's not what we consider to be the rationale contemplated by the legislature in delegating authority to the department to make this decision.
The expert that NextEra called, you described, I believe, his qualifications, I believe it was a him. Did he said that the NEPOOL GIS tracking system will not accomplish what the DPU thinks it will accomplish. Did he identify any way in which it could be done if not through NEPOOL?
No, he said it was not capable of being utilized in that manner.
I guess my question is broader. So did he identify, is it that basically the NEPOOL is not the right system to track this, or that essentially it is impossible to be tracking whether or not the power we're getting is coming from hydro as opposed to a mix of other power sources which Hydro-Quebec has within its arsenal?
I don't know the answer to that question, Your Honor, but I do know, as I referenced earlier with regards to Vermont, there is certainly one way to do it, and that is to hook up a line to a hydro facility. And I would submit that that would be one way in which the parties could assure that they are getting what they paid for.
But am I correct that the plan is for Hydro-Quebec to be taking this power from multiple hydro plants?
You are correct, and multiple hydro plants can also be tied to a single line.
What's the geographic range of the hydro plants? Do we know?
I don't know that standing here, but I would also say, Your Honor, it's fine that Hydro-Quebec is contemplating using multiple facilities, or says it is. It doesn't necessarily have to. One could tie into less than, I don't recall the number offhand, but it was a significant number. I want to say 62, but one could tie into less than 62 facilities and generate the type of power needed.
Right, but doesn't the number of facilities provide more flexibility in the event that, again, there's a drought in one area and that particular power plant just simply can't generate the power that it used to? The hope is that it may not be touching facilities further north or in Manitoba or other locations outside of Quebec.
It certainly does, and again, that's one of the reasons why one could tie into multiple power facilities, multiple hydro power facilities. And what I would say, Your Honor, is that, these are all things that were capable of being contemplated by the legislature. Legislature said it wanted hydro power alone. The legislature was willing to pay for hydro power alone. The legislature contemplated, being able to track hydro power alone. All of those policy objectives suggest that they were contemplating that you would get exactly what you're asking for, hooking into hydropower, not some fungible source that you pay extra for and yet it goes someplace else.
Well, I guess the question then is, what if the legislature did not understand the complexities and challenges of actually establishing the certainty that the power that they were getting is hydro?
Well, I don't think that there are those significant challenges, and I don't think the department found that there are those significant challenges. But more to the point, even if the legislature...
I'm going to stop you. You just told me that you were not aware of any alternative to NEPOOL except essentially having the transmission lines go directly from the hydro plant into the tracking station in Maine.
Correct. That's my point. There are alternatives available that are not necessarily... I don't consider the idea of hooking a line up to a hydro facility or multiple hydro facilities to be a technological challenge. It's been done in other settings. And I would say that, one must also, while they're contemplating what the legislature asked for, one must also contemplate the possibility that the legislature knew exactly that it had been done not just in other far-flung locales, but in other New England states.
Okay, I have no further questions. Any other questions from any other justice?
I have two follow-up questions.
Justice Kafka, go ahead.
So the LMP pricing, you seem to be backing away from any argument based on LMP. Is that correct?
No, not really, Your Honor. What I suggested is that we don't know whether or not LMP pricing would result in inefficiencies. There were no findings in that regard. What the department said is that it could result in inefficiencies. And our position is that without adequate findings, one cannot reach an appropriate determination about LMP pricing and whether or not it's an appropriate excuse for not providing firm service.
But I'm confused. LMP pricing, I thought basically you've got too much supply, so it's basically a zero price for this, below zero price for this. And we don't want to generate unnecessary power, even good power, right? So why isn't it appropriate to defer to the department on that point?
Well, I think if I interpret your question properly, you seem to be and again, I say this with appropriate respect, you seem to be walking around the idea of LMP pricing necessarily leading to cost inefficiencies because of its very nature, and shouldn't we defer to the department on that? If that's...
Isn't the definition of LMP is basically we don't need the power at that point, right?
Correct.
So if we don't need the power, why are we requiring them to provide it?
And I would, and I believe that this is responsive to your question with a question. I would then ask, if that is the inevitable result, why then did the department not say that LMP pricing would result in inefficiencies as opposed to could? Why did it suggest that, there might be different outcomes? I am not an economist, and therefore I can't speak to, the pricing model in this respect. But I do find it intriguing that there was no certainty in the department's position.
My last question is, does the NEPL system properly figure out whether they produce the 9.4 million watts, they're supposed to produce megawatts, whatever those are called, MWH? Does it track that?
I do not know the answer to that question, Your Honor.
Okay. That's all I've got. Thank you.
Okay, any further questions? And hearing none, thank you, Mr. Frechette, and now we'll hear from Mr. Petros.
Thank you, Your Honors.
Good morning, Your Honor. It's Jerry Petros, appearing as Special Assistant Attorney General for the Department of Public Utilities. May it please the Court, I want to begin by thanking the justices for accelerating the hearing on this important matter, particularly in light of the challenging circumstances and times we find ourselves in. I want to begin with one of the questions that one of the justices asked. You asked whether the covered damages provision just came out of the blue. And I think counsel may have erred. It did not come out of the blue. It was part of the solicitation proposal. So parties knew, all parties bidding on this knew from the very beginning that there was going to be a covered damages provision. And in fact, Your Honor, the independent evaluator, who was very important in this process and brought much experience from several people, strongly encouraged the EDCs to negotiate that covered damages provision, thought it was very important and very much endorsed it. So let me start with that sort of firm service piece and work to the covered damages provision, because I think it's been misunderstood in the argument presented by NextEra. First of all, it's clear that the power purchase agreements expressly require Hydro-Quebec to deliver power on a firm service basis. The department made that finding in 10 different places in their order, and the independent evaluator, with all of his experience, confirmed that the PPAs require firm service. Now, NextEra contends that they don't really provide firm service, and it relies on that language in the 83B definition that includes the without interruption language. But even NextEra acknowledges, as it must, the fatal flaw in its argument. NextEra confirms in its reply brief in footnote 4 and on page 16 that the department correctly concluded that both supply and transmission interruptions are inevitable. I think that NextEra refers to them as unassailable realities, and that is correct. And NextEra further concedes that the department correctly declined to interpret the 83B without interruption language literally. So the question is not whether the PPAs can allow interruptions, but whether they reasonably deal with interruptions. It's not a legal question. It's a question that's consigned to the experience and technical competence and specialized knowledge of the department. Now let's talk about those interruptions, because I think there's been a misimpression conveyed by NextEra that these interruptions could be anything for 20% of the time, and that's not true. There are only a few provisions in the agreement that deal with or permit interruptions. First is provision section 10.1, which is the force majeure provision, which NextEra acknowledges in footnote 4 is an appropriate provision. So let's move on from that. The next provision is very important. It's section 4.3C, and that deals with delivery shortfalls. And specifically, it deals with transmission interruptions. And NextEra itself says in its brief that NextEra certainly does not dispute that unplanned outages occur or that a transmission owner may need to conduct maintenance that results in an outage. And that's where it refers to these as unassailable realities. Now, the important point here, Your Honors, is that the delivery shortfalls in 4.3C are all beyond the control of HQ. These aren't things that HQ Hydro-Quebec controls. So that brings us now to the covered damages provision. The covered damages provision is a combination of 4.3A and 9.2F. And what it says is there are ways that Hydro-Quebec can cure unexcused outages. Force majeure is an excused outage. Some of these transmission outages are not excused. And it says Hydro-Quebec can cure those outages. But if it doesn't, then the covered damages provision applies. Now, let's talk about that for a moment. The department expressly found on page 79 that any long-term power purchase agreement has to contain reasonable provisions to address these interruptions, and so did the independent evaluator. Second, this covered damages provision, it's a make-whole remedy for the ratepayers and for the EDCs in the event that there are unexcused interruptions. And I cite the court to its decision in Riggs versus Sokol, 318 Mass 337, where this court distinguished a provision for a remedy like this, like liquidated damages, indicating that that's not an excuse for non-performance, it's a remedy. Third, the covered damages does not authorize any interruptions. That's a critical point, Your Honors. It doesn't authorize interruptions. It says for these unexcused shortfalls, if they're not cured, then these are the make-whole damages, which are significant. They make the ratepayers and the EDC whole, that you will have to do. But there are all kinds of other reasons for interruptions that are expressly not allowed by the PPAs. For example, HQ can't just stop selling. They can't sell the power to somebody else, as NextEra suggests. They can't arbitrage it in that way. They're required to provide specific amounts of power pursuant to a monthly schedule that spells it out. And finally, Your Honors, very important, this 20% figure, it's not a prediction or a forecast that power will be interrupted 20% of the time. To the contrary, power can only be interrupted and covered by this covered damages provision for those very narrow purposes expressed in the 4.3 section I referenced, 4.3C. That's it. They can't sell it to somebody else and say, oh, I'll just pay you covered damages. And they can't just decide not to produce power and say, oh, I'll just pay covered damages. That's a default under the agreement. So don't look at percentages. It's not about it's going to be down for 20% of the time. The circumstances where it applies are narrow under the PPAs, and nobody testified, as my colleague said correctly, nobody suggested, and nobody would suggest, that outages of 20% will be there. That number, Your Honor, I think is there because, remember, this is a large, complex commercial transaction involving billions of dollars in infrastructure. HQ has to finance. NECC and NECEC and CMP have to finance. Banks hate defaults. So it's hardly surprising to see that HQ would have negotiated a provision that would be generous in terms of not with the remedy, because the remedy itself, the make-whole, is quite stern, but saying we're not going to have a default provision that's going to click in if there's a few days of interruptions, because I can't finance a huge multi-billion-dollar project if that's the case. So I suspect the 20% is there, Your Honor, for financing reasons, but there's no testimony in the record by anybody that it would ever occur. And more importantly, it's limited to specific circumstances. If the interruption is outside of those circumstances, then default provisions apply. Let me pause for questions here, Your Honor, if I may.
Justice Gaziano.
Yeah, thank you. Kind of a broader question. Is the department stuck by some statutory language that is rather strict? And it seems to me that the department is trying to take the PPAs and realistically interpret them, but the guidance that we have to, foremost guidance we have is the statute, and the statute's very strict as opposing counsel points out. So is it more of a stretch to get to an end result, or can you tell us what happens with the statute and what leeway should we give the department in kind of going around the statutory language?
Yes, and Your Honor's question drills right in on the interpretation issue, Your Honor, and I respect that. And here's our response to it. Look, power purchase agreements that would permit no interruptions are a practical impossibility, as even NextEra concedes. I mean, a literal definition of without interruption would cripple 83D. There'd be no contracts, no energy, absurd result. What I think the answer is, Your Honor, is twofold. Number one, I think what 83B really means is that there has to be a commitment to firm service for a definite period of time. And in this situation, HQ is committed to provide firm service for a 20-year term. That's what they're permitting. And that commitment is without interruption. What I think we've gotten caught on here is trying to take what I think is imprecise language, because interruptions have an industry meaning that perhaps the legislature wasn't aware of. And what we're now talking about are outages. So there's no interruption of HQ's obligation to provide firm service. That goes for 20 years without any timeouts. What there are provisions that deal with inevitable real-world outages that the department found were going to happen, and that NextEra, as a major player in this market, also fairly and reasonably conceived is going to happen. There's no way around it. So I think, Your Honor, that's how you reconcile that without interruption language, and I think the department, with its expertise as the agency who's enforcing this provision and drafting regulations under it, is entitled to deference, and I think their interpretation is quite reasonable. I'll add one piece, Your Honor, no one's talked about. If you look at the second part of the 83B definition, it specifically says, including but not limited to multiple hydroelectric run-of-the-river generation units managed in a portfolio that creates firm service through diversity of multiple units, close quote. I think the Chief Justice maybe had referred to that. This project falls directly under that safe harbor provision in that definition because HQ is providing 62 hydro generation units throughout Quebec to provide firmness, because with that diversity, it gives you firmness in case one goes down, you've got 61 others to rely on. So that's the second way to get there. I think we meet that safe harbor provision.
And I appreciate your swimming pool analogy for the hydro-only issue. Is it, as counsel would have it, that you need proof basically going from the hydro plant to Massachusetts to ensure that it's hydro-only, or is this a question of physics, as I think you imply, that the power goes into a grid, and whatever goes into the grid goes into the grid, and the end result is the energy generated to Massachusetts? How does that play out in other states as well?
So three parts to that answer, Your Honor. So first of all, NextEra says two different things. First, they say somebody else might put some fossil fuel power or non-hydro power on that Quebec line. And my answer is, so what? None of that offends 83D. We've got to make sure that there are 9.45 terawatt hours of power coming in to ISO, but nothing in 83D says there can't be an additional 2 terawatts of other power purchased by some other party. So the mixing of electrons is irrelevant. But on the tracking issue, what NextEra is really arguing, if you look at the brief and the testimony, is they're saying, there's not a way to physically track. NEPOOL doesn't physically track power from a generation unit into ISO New England. And that's true, Your Honor. And the answer is because it doesn't need to, because it hasn't for 2 decades, because under the rules, including Rule 2.7 of the NEPOOL rules, that's already taken care of. And the way it's been done for 2 decades is that the generator has to certify to NEPOOL under specific regulations, 2.7 is one of them, a rule, that they generated the power and where the power came from. And then it's up to the NEPOOL administration to accept the certification or to question it. And then once they accept it and the power, they measure the power with meters as it comes into New England at a delivery point. And then it certifies, once NEPOOL certifies that power was clean hydro that came in from, in this case, HQ, then that meets all of the 83D requirements. So, Your Honor, just to be clear, this process is followed and has been followed by 2 decades by every state in New England, by all the players, including NextEra, which is a major player in New England, and it has been applied for decades to suppliers outside of New England, including suppliers from Canada, sending energy into the market.
What's the Vermont exception that was mentioned? Is it because Vermont is so close, or where is that?
Yeah, so NextEra's suggestion is, hey, let's just build brand new lines and we'll connect all of these hydro facilities directly to the place in Maine. Well, the problem with that is it ignores the purposes of the statute. 83D says you have to be cost effective. You can't just start pouring money in because someone decides that the gold standard for GIS tracking is suddenly not good enough for this project. So go spend hundreds of millions of dollars and build new lines and take a cost-effective project and make it very expensive. And that's the problem with that solution. Would it work? It would work, but it's not feasible. Nobody else does it. This system's good enough for everybody else. It's good enough for this project.
Thank you. That's all the questions I have.
Justice Louie. Louie, you may need to unmute.
The issue of the the transmission lines and the tracking system and how well the tracking system works seems to go hand in hand here as to whether or not hydroelectric's only delivering the appropriate energy, the hydroelectric generation. And I guess what I'm hearing from NextEra is that the hydroelectric energy that's coming in, because of the nature of the transmission lines and what they're near, coming in from Canada, that we're in a situation where there's just no way to tell whether or not the statute's being complied with. So I think the argument about the transmission lines goes hand in hand with the issue of the tracking system. So how do we know whether the department analyzed that well enough when we have heard from only one expert, and it was from NextEra?
Well, you've actually heard from more experts, Your Honor. Let me try to address that question. First of all, another expert we heard from is the Department of Environmental Protection. They're charged with tracking this power under the Global Warming Solutions Act, which we talked about. And DEP has extensive experience with these issues for that same reason. DEP provided an advisory opinion that is part of this record, which we cited to, confirming that the tracking mechanism, the NEPOOL GIS system, was appropriate here. So that's one expert. The second expert is the department. The department actually participated in the creation of the NEPOOL system, and including the tracking system, has extensive experience applying it, has done so for decades, has a number of decisions we cited to them where they deal with those issues. So there's a second expert. The department has extraordinary expertise in this area. And the DEP and the department both explained how the system works and the fact that the system is working here the same way it always does. Your Honor, there's nothing unique, even though it's in Canada, there's nothing unique about this generation. It's outside of New England. And when you have somebody outside of New England or inside New England the generator has to certify where the power came from. NEPOOL doesn't send out agents to investigate and inspect what these major players, HQ is one of the largest suppliers of energy in Canada, what these major players are representing. Now, it may have due diligence it performs, Your Honor, I'm not sure of it, but that system is the same system that's good enough in every other case, and it should be good enough here. And one final point, Your Honor, and you're right, it's very much, with these two issues, very much related. Let's not forget, the PPAs specifically require HQ to deliver power only from the 62 hydro units that are identified on Exhibit A. And NextEra concedes that the PPAs require that. So let's not forget, there's a contractual obligation here, and we shouldn't assume, and this court says in Riggs that we shouldn't assume, the assumption is that parties are going to meet their contractual obligations, and the PPAs contain reasonable provisions requiring hydro only, and extraordinary enforcement provisions if they send something other than hydro, they'd be defaulting on a 20-year contract that involves billions of dollars. So there's ample levels of protection here in terms of ensuring that it's hydro only, and ensuring that it's tracked appropriately. And finally, Your Honor, express findings by the DPU. HQ is a major wholesaler. It's undisputed that it generates far more hydro from these 62 than is being purchased here. So everything is in place, and the contract requires compliance.
All right. Thank you, Ms. Petros.
Yes.
Thank you, Your Honor.
Justice Bud.
I have no questions. Thank you.
Justice Safer.
I have no questions either. Thank you.
Justice Kafker.
So back to, you say the cover damages didn't come out of the blue, but that wasn't the question I was asking. I was asking whether the 20% figure came out of the blue. Was the 20% issue brought up, or just the remedies for this?
So Your Honor, what happened is different parties submitted proposals. There was an evaluation process. A proposal was selected, and then the EDCs engaged in contract negotiations with respect to that proposal. So the proposals were negotiated after the quote winning bid was selected. In fact, the first winning bid dropped out because an approval wasn't had. So I can't share with you. I can't.
Can I be a little more specific? Can I be a little more specific though? So in order to bid, you need to know just what you say, how much room you have. Remember, you said the banks are going to care really about, whether there's a realistic, flexibility in the contract. So I'm just trying to understand how everyone could fairly bid if this 20% figure hadn't been presented earlier.
Well, there are probably different risks with every project, Your Honor, so it might not have been 20% with a different form of energy and a different supplier. And it could have been negotiated at 15%. There's no magic. There's no talismanic quality of the 20%. My point is only, it's a business term, that was negotiated, and you can understand that, someone in HQ's position would not want to be in a default position on a 20-year contract involving billions of dollars of energy. I mean, this is an enormous, unprecedented contract providing 18% of the power to the state of Massachusetts. But the important point there is a little bit of a so what. 20% is a cap after which there would be a default. But first, they have to pay an extraordinary price to cover if there are interruptions. And second, there are very limited interruptions which ensure that it's not going to get close to 20%. We're really talking about transmission outages. And that has to be in there. I'm sorry, Ron, go ahead.
When I go read this big record then, I'm not going to find anything about the 20% until the contracts are negotiated later, right?
I think that's correct, Your Honor. The one thing you will find is the independent evaluator was very much a supporter of this provision, and I think you'll find some analysis by him. By the independent evaluator on that issue.
And the other bidders, okay, so then the other thing, all I can think of is the SALT talks. We trust, but we verify. So it sounds like NEPO requires certification that you provide the 9.4 megawatts, right?
Correct, Your Honor.
Do they have any capacity to verify that? I mean, it's clear your clients can produce 9.4 million megawatts, whatever the term is. Do they have any capacity to know whether you provided that 9.4, or is it just trust?
Well,
Do
first, Your
people
Honor,
have a verification besides the certification process? How does it work? How does it verify, I guess, is the question.
So just initially, Your Honor, again, not my client. I represent the department. That's HQ.
Right.
The way it works, is that NEPOOL has a long-established process. It has multiple pieces to it, but one piece is that the generator has to certify. You use the right language. They actually have to certify to NEPOOL that they're delivering energy and where the energy is coming from. And NEPOOL tracks energy, and this contract requires the tracking of energy on a unit-specific basis. So that certification would be on a unit-specific basis as it comes forward. Now, what I can't tell you, Your Honor, is that NEPOOL sending somebody out to that unit to measure. That's impractical. But what I can tell you is that this certification process and verification process is exactly the same process that the market, the department, and courts have accepted for 2 decades.
Okay. That's all I have. Thank you.
Thank you, Your Honor.
Just a few questions. With regard to the testimony of the NextEra expert, I guess it was not addressed at all in the opinion.
It was not addressed. You're correct, Your Honor.
Okay, so why don't you hear, and I think at least I would have felt better if it had been addressed. So why don't you identify what the experts, I gather the gist of what the expert testified to is that NEPOOL is not going to be able to accomplish what it is supposed to do.
Well, he did. Well, what he said, Your Honor, and I'm going to paraphrase, but what he said was that, first of all, there's not a physical tracking mechanism in NEPOOL. But as one of your colleagues said, those are the NEPOOL rules that's the gold standard that everybody's been using, including NextEra, for 2 decades. So, you really should go talk to NEPOOL. But no one's ever complained about that tracking mechanism and the lack of a physical tracking mechanism. So that's one of the things he said. And then he said he was concerned that some non-hydro could flow over the line. He admitted that he didn't conduct any analysis on power flows. And finally, Your Honor, he testified that HQ would deliver system power, and that's important. So system power means HQ has a big system. It's predominantly hydro, but there might be 2% that's non-hydro. So he said, well, they're delivering system power, so 2% might be non-hydro. Well, that's wrong, because the PPAs require unit-specific power, and the tracking of the NEPOOL also requires unit-specific certification. And so that expert had at least those 3 errors that I can identify. And again, that wasn't the only expert testimony. You had DEP certifying this to be an appropriate, acceptable tracking mechanism, and DEP is required to track under the Global Warming Solution Act. It's a statutory obligation. And second, the department itself, with extensive experience in this area, also found that this was an appropriate tracking mechanism.
The NEPOOL, is that a private corporation?
It's an association comprised of states and power players. Like, I'm not sure if NextEra is on it, but there are lots of sellers and generators like NextEra, and including the EDCs that make up NEPOOL. It's a cooperative association that helps manage the system to make sure we can move power around New England efficiently and track it.
I have no further questions. Are there any other questions of the justices?
I just have one last one. I couldn't understand NextEra's response. Did they bid on this or not?
Yes, they did. And they
bid, and okay, all right. And did their proposal have a different provision than this 20% in it? Did they provide 100%?
Your Honor, I did not review any of the other proposals so I don't know what was in there for cover damages.
Okay, thank you. That's all I have.
Thank you, Your Honor.
That concludes our oral argument. We shall right now change lines and we shall commence the Justice's ensemble on the case. Thank you so much.